Good morning, everyone. My name is Edie Bogaczyk, and I am a special education attorney. And the reason why I got into this field is because of my son over there, Zachary Bogaczyk, who is born with a really rare genetic syndrome called Prader-Willi syndrome. Probably, oh gosh, years ago when he was just about 2, I was in the area of bankruptcy law. And I realized I have a son who's almost on the cusp of being 2. I don't know anything about the Americans with Disabilities Act. I don't know what his rights are. I'm trying to get these early services for him, and no one that I knew anything. And similar to our earlier guest speaker, I just moved to Iowa. I'm from Canada. Went to Michigan, moved to Iowa for my husband's job, very similar. I had a 7-week-old, a 1.5-year-old, and didn't know really anything about the law, how to even get services, didn't even know what a waiver was. And then I realized I probably should learn. And then at the same time, many of you probably heard of Disability Rights Iowa. They're going to be presenting today. There was an opening for the legal director position. So I said, you know what, I'm going to apply for it. And I told my husband, I probably won't get it because I only have bankruptcy and other areas of law I don't know anything about. Well, you know, they said, you get it. You're a parent. You live it and you breathe it. And we can see how much you're fighting to want to be an advocate. You know, you have the law piece that we don't have, and you also now, and then I did that, and then I'm now in private practice because I want to be able to do, I want to be able to serve as many people as I can, regardless of being confined to a certain priority. And also, I do a lot of mental health and substance abuse law. So half my practice, and there's very intertwined. They're very intertwined. So I'm one of the few attorneys, I think, in the state of Iowa that kind of dedicates herself to that particular area. I serve all 99 counties. I go everywhere. I have that luxury as well to assist. And so this whole area has been dear. And Zach is now 21. He's going to be 22. So tells you I've been doing it for about 2 decades now. And so we're going to get started into prior written notice. And Karen knows how important this is near and dear to me. And can I just get a little bit, are all of you parents, educators, providers, mostly parents? I was so shocked that I want parents to know prior written notice. You hear me say PWN just as much as they hear IEP. Everybody kind of, once you get into this and your child gets eligible, you kind of know IEP, but nobody knows PWN. And I'm still shocked to this day when I even represent high school students and parents go, what's prior written notice? I said, your child has had an IEP for almost 10 years and you don't know. That means the system's failing. That's not on the parent. That's on the system. That's on the school districts. That's on the AEAs. Like, what do you mean you don't know? The IEP, the prior written notice is even almost more important than the IEP when it comes to your parental rights, your legal rights. So I've made it my mission to try to spread the good word about prior written notices because I think it's going to strengthen your ability to advocate because you're going to know what the requirements are and you're going to know your rights more. And so, and I was sharing with one of the parents when I first got here, when I do my PowerPoints, I like to put so much information in there that you don't have to worry about taking notes, that you can just sit back and listen, because I think that this is so technical and so important that I'm kind of the opposite of how a lot of presenters will do it. They might just put a topic in there, and then they have all those blank. I want to give you the information because I don't think it should be a secret. I don't think you have to, and I don't want you to get it wrong with trying to translate it because it's so precise. And like I said, these are your rights. So there's so much information in there that you probably won't have to write too much. And I just want you to soak it up, especially if it's new, if you're new to this area. But I want you to be able to listen. And then if you need clarifications, I can stick around at the end. I think I'm just going to quickly touch on, I'm going to have to put my glasses on. I just have a disclaimer at the beginning because I am an attorney, and this happened to me once before where we had a parent who was at one of my sessions, and I've been teaching here a long time, right, at your conferences, and I was so shocked to get an email where she included me with the superintendent, the principal. She goes, and my lawyer said, and she included me in the email because she came to the conference and I told her what her rights were. And I was like, oh no, like this isn't legal advice. Yeah, I'm telling you how to advocate for your legal rights. But I'm not your attorney, and I know all the situations, but I was like very thrown aback, so I had to explain to the school district that, I'm just not representing the individual at this time, but if she chooses to retain me, then I will be part of this discussion. So I just wanted, and also because all of our situations are different, and people who know me will know that I'm the biggest advocate of the letter I. Because I find that I've worked in so many school districts with so many different AEAs, and I just feel like because maybe of lack of resources or a lack of training, but they try to cookie cutter and they do it by disability, on the spectrum, Down syndrome. And I find that they still forget the I, like individual, which starts with the IEP and the Iowa Disabilities Educational Act. The I is so important because you could have so many, like my son's disability, it's a spectrum as well. So when I advocate, my husband and I are co-presidents of the Prader-Willi Syndrome Association of Iowa, and we try to help parents with plans or help parents like working with their group homes on how to set up the best plan there. They're all different. So I find that sometimes they're boxed too much, and I'm often saying we forget about the I, and that's like also one variable can change a thing. And I have parents who, we all like to talk because I think we are each other's tribe. And sometimes parents get frustrated and say, well, they got this, but I didn't. And I said, but there could be one variable that's a lot different that could change the way your child might need services. So that's why we don't want to lose focus of the I. Okay. Prior written notice. And do you hear PWN? And if you don't hear PWN or you're going to get notice, that means the school district and the AEA aren't doing their jobs. And just in case there's anyone here that's from the Des Moines school district, Des Moines is the only school district in all of Iowa that doesn't really facilitate with the AEAs. Like they kind of do everything in-house. So it's just the Des Moines Public Schools, and they provide what the AEA provides, those services, all the related services that we can touch on later. But it's a procedural safeguard right. And if you go to an IEP meeting, you get that book, and in that book, there's 10 procedural safeguards, and one of them is the prior written notice. And that's what we're going to focus on today. But there's 9 other really important legal rights that you have as a parent. So I always tell parents, I know they give you that book, but take it and read it and highlight it, because they do like now a 2-second version. I'll give you a quick rundown of your rights, but do you really know them and absorb them? So I tell parents, I said, that's got to be like a living, breathing document. Like that's kind of like our Bible, you know what I mean? Our holy grail of our rights. So now you know that there's 9 other important rights that I'm not going to touch on today, but maybe over the years we'll just keep adding. But one of them is the prior written notice, and that is guaranteed to you. And then, and I'm going to tell you it's required because the prior written notice is kind of like the roadmap to your IEP. The prior written notice, what it is it's where a whole bunch of decision making comes into play. Really important decision making. And then it's the roadmap of how the IEP is going to get implemented and why. So they really go hand in hand, but that piece talks about, it has to legally talk about how that decision making came about, because then it guarantees your rights if you want to challenge it. But it has to be in writing. It has to be in writing. And I work with a lot of parents who say, well, they just called me over the phone because they don't like to put anything in writing. And I said, no, Congress says the prior written notice, where we talk about where all the decision making occurred, has to be in writing. And they can talk to you about it over the phone. They can talk about it in the hallway. But notification means written notification. And so I just want to read this one paragraph because I think it's so important, where I found it in a case. that prior written notice is required to ensure that the parents and guardians of a child with a disability are both notified of decisions affecting their child and are given an opportunity to object to these decisions. Because that's where you have your, that's where you're going to have your say, is like, I don't agree with it. And so they have to list all of these. And whenever I say that, you know, when they talk about the decision making, what was discussed, what was requested, what was rejected, you know, a lot of parents will say, oh, this was rejected, and I never, and there's seven, there's like a very small amount of categories. There's like, I think 4 areas that we're going to talk about of where you are entitled to a prior written notice in these 4 areas only. So it's not any request that you make. The law says we're going to narrow it down. There's only certain requests that you make that they have to explain why they're accepting your request or why they're rejecting it. So it's not any request. So they still narrowed it down. And I know later this afternoon, in terms of age and majority, they're going to, Len Sandler from the University of Iowa, he's going to be talking about students who are 18 and kind of on the cusp of transitioning. When I talk, I usually just talk about parents or guardians. But it's really important to know, the reason why I said including majority learners, because not everyone who turns 18 automatically will get a guardian. However, all of the legal rights, including the prior written notice, right, the procedural safeguard rights, transfer over to the student when he or she turns 18. Which means that legally they can just start corresponding with your child. They don't legally even have to invite you to an IEP meeting. So, and that's really important for parents to know, to start thinking about it. Do you think your child can really make a lot of decisions? Because there's also that post, like the vocation program until they're 21, looking at goals. Do they meet their goals? What kind of classes should they take? Who should they be inviting to the meeting? Should they start inviting Voc Rehab to the meeting? So legally, they can do that. So I think it's really important too that if your child doesn't need, you don't think you're going to go down the guardianship route, maybe just do power of attorney, but then try to have, talk to your child who's 18 or just before they're 18 about maybe signing a consent form. Because and then if you can sign a consent form, then, you know, to share your information, then at least you could be part of the process. Or make sure you have your child invite you to the IEP meeting. But this has happened. And I don't, you know, I'm going to be honest with you. I think ethically, you know, if you've been working with a student and you know that their parents been advocating and you know that they probably need some supports to make some decision making, I really do feel that the school district and the AEA should be reaching out to them and really having that conversation before they turn 18. And discussing, you know, what this is going to look like by the time they become age and majority. But again, you want to make sure that those rights, if you're going to be part of it, transfer to you, and then you'll have to probably set up the guardianship in time so it coincides, you know, on time, especially making those decisions after 12th grade. And so I think we briefly talked about how it's in writing and how they propose changes about the child's educational plan. And I'm going to get into detail, but I think it's really important that it's also written in a way, and I think I might be coming up to the next slide, it's written in a way that you understand, and we're going to be talking about that in a few moments. It could come from the AEA or it could come from the school district, and again, in writing, and it can also be by email. I actually like it when it's an email because then I can print it out, I can save it into an electronic folder, it's always there. You can resend it to yourself, so you've got it in more than one place. I've had issues and I've actually had to litigate them where they said, well, I stuck it in the child's backpack. And we're like, we never got it. You know what I mean? Or I gave it to the kid to take home. Well, did they put their shoes on and leave it somewhere in the hallway? And I would really probably, something that's important and that sensitive, I wouldn't want the prior written notice just shoved in a backpack, or I think that is so important. So when you're at an IEP meeting, I always tell parents, I said, make sure before you conclude, ask, you know, if you're gonna have, who's gonna send it to you and how you want it. But it's gotta be in writing, and it's gotta be something that, and it's got to be a communication of how you're going to expect it. I think the expectation of how you're going to receive it is so important, and that's never discussed. When I talked to my parents, they said, I don't even know if I got it. And I say, well, let's go back and look at the IEP. Let's go see if we can find it, if it's stapled or if it's somewhere in a document. And I just find that this is overlooked. This is overlooked all the time. There's never any type of more objective, blatant communication from the school district or from the AEA about where this prior written notice is. I think it should be, if it's going to be an electronic, I think it should be highlighted. You know what I mean? In the subject, not just IEP. I think it should be, or final doc. I think it should say IEP and prior written notice, or if it's just the prior written notice. I think people, but communicate that, and that's where your self-advocacy piece could come in, by sharing that. Did you get a PowerPoint presentation? Okay, great. And I think the reason why it has to be in the language that's so comprehensible is because you have to know this is a legal document. This is what's going to start your statute of limitations. There's a 2-year of statute of limitations to file an action if you reject something. Or if you're not agreeing with their giving you. We're going to give you this, and you don't agree. You think it should be different type services. So the way that they give you the language, it should really be, it shouldn't be vague. It shouldn't say some, it should say, you know, these services are going to be provided and they'll be written into the IEP, right? The prior written notice isn't supposed to replicate the IEP. It's not supposed to have all the nuts and bolts. Don't forget, the prior written notice is, like I mentioned earlier, is the roadblock. It's going to, not the roadblock, it's going to be the road that will travel you to the IEP, but it should be kind of like, these are all the areas that we're going to talk about. These are the areas that we accepted or rejected, and then those will be reflected in the IEP, and the IEP is going to be all the nuts and bolts. So sometimes a prior written notice is a page and a half. They're not supposed to be super lengthy unless you had 40 different asks that are all within the area of the law, but they're usually not that long. And I know a lot of parents will say, we want to put everything in the prior written notice. I said, you can't, because it's not supposed to describe in detail how those services are going to be implemented, just whether you're going to get those services. But it shouldn't just say related services. It should say PT, it should say OT, it should say speech. So that's what I mean. It should be so you know exactly what you're agreeing to. It shouldn't be any vague. If you look at it and you see it's vague, then that means it's not written properly. And that's not written within what the Congress expectations are. And then, does that mean, and I mentioned this earlier, any type of ask by the parent has to be in there? No. These are the only areas. Remember how I mentioned there's a very small group of area that triggers a prior written notice. And these are the triggers. The second bullet here. The school district must provide parents with prior written notice whenever it proposes or refuses to initiate or change the identification, whether your child is going to be identified for special education services, evaluation, that's the initial evaluation or the reevaluation, educational placement, and remember, educational placement is not a location or a building, it's the actual services, and that's, you know, the biggest thing I get is the bricks and mortar. It's not the bricks and mortar, it's not where you get, and I spend a lot of time working with parents and helping them understand it. For example, it could be from general education into special ed, or changing the number, right? Like 50-50, whereas before it was 100% gen ed now. So when you think of placement, you think of services. And then the last one is provision of a FAPE. And that's really all the details, right? All the accommodations, the goals that you're working on, all those services, the modifications, so FAPE. So if it's relegated to one of those 1, 2, 3, 4 areas, then that triggers a prior written notice, and they have to give you a prior written notice by law. They have to, because that, again, is going to trigger your ability to challenge it, and you have a 2-year statute of limitation from once you receive that prior written notice. And then I always like to tell parents where this law is, because I'll be honest with you, before I usually get to an IEP meeting, and I go to a lot of IEP meetings, because I feel that it's important to try to resolve things at the lowest level. And you could go, for example, you could go to 5 different doctors and get maybe 5 different diagnoses. Just the same way you can go to 5 different special education attorneys. And you can get some that will say, oh my gosh, we're filing a lawsuit today. I'm not like that. So if you ever were to call me, I'm the type that says, you know what, is there any possibility we can resolve this at the lowest level, because it's in the best interest usually of the child to just get those services as soon as possible and move on. Because when you get litigation involved, and this is, I think, another PowerPoint that needed to stay put, everything freezes. So think of a big stop sign, and that means your child isn't going to get a lot of important services until all legal matters get resolved. So that is, and also as a parent of a child, and Zachary does require 24/7 supervision, I feel like we have to also take care of ourselves, right? And our own, self-regulation, and what hill are we going to die on? And what are we going to really pursue and advocate for? So I do go to a lot of IEP meetings, but I think it's very interesting that before I get there, there's a lot of staff that will tell the parents, it's the law. That's why we have to do it that way. And the